This is Barry Zalma speaking for Claim School Incorporated's blog Zalma on Insurance. Today we're going to talk about poor Zing Zing's owner who was barbecued by fraudsters and still couldn't get coverage for her loss because there is never coverage for theft by persons to whom the insured entrusts his or her property. When the plaintiff turned her restaurant over to two restaurateurs when she became ill, they took out of the restaurant and converted it and its equipment to their sole possession. The restaurateurs claimed they purchased the equipment from the plaintiff, and she claimed they took advantage of her illness and stole the property. She made a claim to her insurer, State Farm, who denied the claim because either cause alleged was due to a peril not insured or a peril specifically excluded. In Tomazina Johnson, DBA Zing Zing's Wings and More, LLC versus State Farm, the United States District Court for the Western District of Tennessee on November 23, 2022, resolved the dispute by reading the full policy and applying the language to the facts established by State Farm's motion. The plaintiff's circuit court complaint alleged two claims: breach of contract and breach of bad faith refusal to pay an insurance claim pursuant to a Tennessee statute. State Farm moved for summary judgment, arguing that plaintiff's claim for breach of contract failed as a matter of law because the policy does not provide coverage, regardless of which version of the evidence a trier of fact would choose to accredit. Specifically, the policy does not provide coverage either if the property was sold to third parties or if the property was entrusted to third parties and removed or stolen by them. Plaintiff argued that the policy provides coverage for accidental physical loss of business personal property and that she had met her initial burden of establishing that the accidental direct loss during the policy period. State Farm had issued a business owner's insurance policy that was in full force and effect, insuring the plaintiff's restaurant business Zing Zing's Wings and More. The policy provided that State Farm insured for the accidental direct physical loss to covered property. However, Section 1 exclusions and the property subject to limitations provision limited the coverages available to the plaintiff. The policy contained the following exclusion: dishonesty. 1. Dishonest or criminal acts by you, anyone else with an interest in the property, or any of their partners, members, officers, managers, employees, directors, trustees, or authorized representatives, whether acting alone or in collusion with each other or with any other party, or 2. Theft by any party to whom you entrust the property for any purpose, whether acting alone or in collusion with other party. This exclusion applies whether or not an act occurs during your normal hours of operation. Close quote. The exclusion set forth in subsection 2G of the policy, false pretenses exclusion, states as follows, quote, voluntary parting with any property by you or anyone else to whom you have entrusted the property, if induced to do so by any fraudulent scheme, trick, device, or false pretense. Close quote. Plaintiff opened her restaurant Zing Zing's. Its grand opening took place in February of 2019. However, while plaintiff was operating the restaurant, it was operating at a loss. On the advice of counsel, plaintiff dealt with two individuals, Curtis Brayton and Rayford Burns, who were to take over Zing Zing's while she was ill. While the policy remained in effect, plaintiff testified that she entrusted her business property and business to Brayton and Burns provided them keys to the business, allowed them to temporarily operate her restaurant, allowed them to use her property and equipment, allowed them to sell food that she had already purchased, and allowed them to use the services of her employees for at least some period of time. Plaintiff testified that while Braden and Burns were doing so, she would continue to pay her employees' wages, the utilities, and all other bills related to the business. But Braden and Burns would pay the rent and keep the profits. During this arrangement, plaintiff did not characterize Braden and Burns as her employees. Plaintiff testified that after entrusting Zing Zings to Braden and Burns, she was contacted by the landlord, who told her that the business was shut down. After receiving this phone call, plaintiff went to Zing Zing's and encountered two neighbors of the business who told her that the individuals she had allowed to operate the restaurant had removed everything out of the restaurant through the back door. Plaintiff reported to State Farm that Braden and Burns stole all of her property from Zing Zing's. Braden's version of events is substantially different. He testified that plaintiff transferred Zing Zing's and its equipment and property to Burns by way of a bill of sale. Braden testified that he observed plaintiff's initial and signed the bill of sale and that he notarized it. Plaintiff continued to testify she had no idea why her initials and signature were on the bill of sale and contends that it is a fraudulent document. Ultimately, State Farm denied plaintiff's claim under the policy. Plaintiff provided an itemized list of property related to her claim that totals $20,052.48. Plaintiff's first claim alleges breach of contract by State Farm. There is no dispute that State Farm issued the policy and that it was, in effect, at all times relevant to plaintiff's claim. Thus, the legal question at issue here is whether State Farm failed to perform its obligations under the policy by denying plaintiff's claim for coverage. The evidence before the court failed to show that any dispute existed as to who removed the property. Plaintiff informed State Farm that Braden and Burns stole the property, and she personally continues to believe that Braden and Burns are responsible. She entrusted the property to Braden and Burns. If they stole the property as alleged, the theft was excluded. Plaintiff's second claim alleges a statutory claim for bad faith refusal to pay pursuant to the Tennessee Code. To prevail on such a claim, the following elements must be met. 1. The policy of insurance must by its terms have become due and payable. 2. A formal demand for payment must have been made. 3. The insured must have waited 60 days after his demand before filing suit unless there was a refusal to pay prior to the expiration of the 60 days. And 4. The refusal to pay must not have been in good faith. The court determined that the policy did not provide coverage for plaintiff's claim as a matter of law, since both possible causes of loss were excluded. Since plaintiff's claim has never been due and payable, plaintiff's statutory claim for bad faith refusal to pay fails as a matter of law. In my opinion, this is a sad tale of a person who, because she was ill, entrusted her property to two individuals who claim they purchased the property and who she claims stole the property. Unfortunately for the plaintiff, either occurrence was specifically, clearly, and unambiguously excluded. She can still sue Braden and Burns for breach of their contract, but it will probably cause her nothing but pain and suffering to do so. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the link zalma.com/blog. A blog that you can subscribe to so that you could receive notice of the posting at least once every 5 days of the week, Monday through Friday, and sometimes twice or more. You can also view this video on rumble.com or on youtube.com and can subscribe to either service. And I would appreciate it if you do watch the video, that you click on the like button on YouTube and the Rumble button on rumble.com. Please, if you found this video to be interesting or useful to you, advise your friends and colleagues so that they can also subscribe. And you might also be interested in subscribing to my locals community and my Substack publications, where special publications are made only for subscribers. Thank you for your attention.